Welcome to Sakshi TV special immigration talk show with me, Shivani Raj. For today's show, we have Ms. Prashanthi Reddy from Reddy ESQ. Also note that this show every week it is on Wednesdays and also on Tuesdays with attorney Srinivas Kaveti, on Wednesdays with Prashanthi Reddy, on Thursdays with Chand Parvatneni, and on Fridays with Banu Lindra. Please tune in to ask your questions. If you are an immigration attorney and would like to join our special shows, you can definitely email us on the numbers shown on the screen. Without any further delay, let us welcome Ms. Reddy onto our show. Prashanthi Reddy Garu, welcome back. Andy, how are you?
I'm good. Thanks, Shivani. How are you?
I'm doing great. Thank you so much for asking. Ms. Reddy, today we decided we will talk a little bit about the H-1B cap updates. So this is actually basically like a continuation, but you just said that you have many more updates that you want to give this week. So can you start up with the updates?
Yeah, so the latest update, which was received as of today, is that the H-1B cap has been reached. We were discussing previously of the likelihood of there being a third lottery, but it looks like that's not happening. They have announced that they have received enough H-1B numbers to cover the 85,000 H-1B numbers that are available. So we will not be seeing any more lotteries. So, that's that. That's the end of the H-1B cap season this year. Now we have to wait for the next year cap, which is going to be starting in March. So get your applications ready, get your information ready. Most probably the registrations again for next year's H-1B cap will start in March. And you should be able to file your petitions by August 1st, and you will have 90 days to file. So you'll have to file all your petitions by June. So it's important to start your recruitment, get all your information ready as soon as possible, by February if possible. Also, it's a good idea to file your registration early in the process instead of waiting for the last day. Because what will happen is if you wait for the last day and if there's some mistake in your application, you won't be able to correct it. And then the time to file a registration will be over. We're also waiting for further information on what this cap season will look like. We are waiting to see if the fee will be increased to $200+ from $10 for the registration. We're looking to see if they will start picking the lottery based on the beneficiary's passport number instead of based on the registrations filed. So this will be really helpful as there won't be duplicate registrations, and so the same beneficiary won't have 10 picks, and then if they are only going to use one, then they'll be waste the rest of the numbers. So hopefully it'll be a much more efficient system. So we have to wait and see. That's the update for the H-1B cap numbers. So going on to the next update that I wanted to do last week, but we didn't have time since we were talking about H-1B layoffs, etc. And we can still take calls on that if someone wants to call us on a H-1B layoff question that they had. But what I wanted to talk about is the executive order that has been published by the White House, Biden's executive order on artificial intelligence. There's a lot in it, but we're only concerned about the immigration part of it. And it seems promising, but we have to wait and see what will happen. Basically, in this executive order, the president has asked the Department of State and the Department of Homeland Security, which is basically USCIS, to take certain actions within 90 days or 180 days, depending on which action they've been asked to take and who's been asked to take it, to make some changes so that it will be easier to bring in people who have an expertise in AI, artificial intelligence. As a result of which, they have asked, for example, the Department of State with reference to consular visa processing. They've given them 90 days to take certain actions to streamline the processing times for visa petitions. As we know right now, availability of visa appointments is it's taking a long time for a visa appointment to become available. You have to wait for 3 months, and in some instances for 6 months for a visa appointment date. So they're asking the Department of State and USCIS to conduct research and see how they can make it easier for people in the AI field to get visas and to get visa appointments as well. So that's one of the changes that, or one of the aspects that they've asked these agencies to look into. Other policy changes that they've asked USCIS to look into is that they've asked many agencies to initiate within 180 days campaign promoting the United States as a prime destination for foreign nationals specializing in science or technology to study or work with AI and other critical emerging technologies. So in order to do this, they've suggested updating their standards for the O1, EB1, EB2, and the entrepreneur visa to see how this can be used to bring in more AI talent. Also requiring the Department of Labor to solicit information from the industries, from the private sector, on where immigrants and advanced skills in science and technology are most needed, so that they can update the Schedule A occupations. So for those who don't know, Schedule A occupations are those occupations which you can just type in Google and see what are Schedule A occupations. But some examples are nurses, physical therapists. So these occupations are known to be shortage, meaning there is a shortage of labor in these occupations, and it's a presumption that there is a shortage. Excuse me. So based on this shortage, now when you're filing a green card for these occupations, you don't have to file labor certification. You don't have to advertise and see if there's anybody in the market available, US citizens available for this position. So you directly file the I-140. So the executive order is asking to see if AI specialists can be added into the Schedule A list of positions. That will really help people in this sector get their green card faster, because then they don't have to go through the labor certification process, which takes about 1.5 to 2 years. Also, they're asking USCIS to continue the H-1B modernization process. Now, there is a regulation right now that talks about various aspects of modernizing the H-1B process. It has not been implemented. It has only been published, and it is still in the 60 days comments period. We don't know which parts will be published, what modifications will be made, and we can discuss that a little later. But they're asking to see what modifications can be further made so that, again, AI people or people in related technologies can come in into the US in an easier way, in a faster way. Also, they're asking to consider new requirements to enhance the process for experts in AI and other emerging technologies and their families to adjust status. This is for filing 485. So they're seeing if there's a possibility of maybe increasing the employment-based numbers for 485s. I hope that's the case. Or maybe being able to file a 485 directly. We don't really know what regulations will be considered, but something definitely to make filing of 485s easier. But let's actually see what recommendations they come up with. Time will tell. In addition to this executive order, there's also been, as I was mentioning earlier, a regulation that has been published, NPRM. As per this regulations, I wanted to just go through what the changes have been proposed in this regulations, and this affects only H-1Bs. And in this regulation, basically, they've said that there must be a direct relationship between the degree and the duties of the position. So they're talking about specialty occupation, which is already the law, but they're seeking to codify it further. And they're also saying a position does not qualify for a H-1 if it requires a general degree without a specialization. For example, if the job requires a business administration degree and doesn't say business administration in finance, for example, or it asks for an engineering degree and does not specify chemical engineering or some specific field of engineering, they're saying it won't be considered a specialty occupation. And this has been their position even previously, but they're, I think, seeking to codify it through this regulation. They are also telling us that, clarifying, I must say that simply because multiple degrees are required for a position, it doesn't mean that the H-1, it doesn't mean that it won't be a specialty occupation. So say there is a job title that requires a bachelor's in computer science, math, engineering, physics. As long as you can show there's a correlation between all of these, it is still a specialty occupation. So it doesn't have to be a major in a single field, which they have said in the past that it has to be. So now they're clarifying that it doesn't have to be a single field as long as they are related. Another change that they are proposing is, and again, there have been RFEs on this, and that's why it's important that they clarify, and they're doing so by saying that as long as a bachelor's degree is normally required for the position, it does not have to be always. It does not mean always. So in the past, they have denied H-1Bs based on the Occupational Outlook Handbook. If the Outlook Handbook says most employers require a bachelor's degree, but some do not. Some require only an associate's degree. They're denying cases based on that, saying that, oh, look, it says some do not. So here they're clarifying that it doesn't mean that the position should always require a bachelor's degree, but as long as it normally requires one, that is sufficient. So that's a good good clarification that they gave us if they intend to stick by it, because then a lot of other job titles, I think, will open up for specialty occupation H-1 positions. The other change that they want to make is removing the itinerary requirement, which as of now, they don't ask for the itinerary. This was based on a case in 2020, IT-Serve versus Cessna. Based on the outcome of that case, USCIS has agreed not to ask for itineraries, meaning what the person will do from day one to the third year of employment. That is already, they are saying, is in the LCA, and that is sufficient for them to approve the case. They've also said that they will increase validity, automatically increase the validity of petition if it has already passed the validity. This happens sometimes when H-1s are asked for lesser periods of time, maybe for a year, and the H-1 goes through an appeal, and by the time the appeal is approved, the period that is they've asked for has already expired. Then there's no point of getting an approval on that H-1. So they're saying that they'll automatically increase the validity period and increase the period of the end date to that of what was initially requested. So if it was 1 year, then they'll increase it to 1 year from the date of the approval. So which is great, because it saves people from having to file the petition all over again, and saves USCIS's resources as well for having to adjudicate the same petition again. Also, DHS proposes to address the H-1B registration abuse that we saw last year. gaming of the system, as they call it. So they want to make sure that they put in several anti-fraud safeguards that would be made to the current registration system to basically make sure the selection process reduces the misuse of the system. So they have proposed that, as I was just saying, that the beneficiary, whether they file 10 registrations or they file one, they should only have one pick at the lottery. And the way they do that is by choosing the lottery based on the unique passport number of the beneficiary rather than based on the number of picks, the number of registrations. So that will really help. Another update that they've said is what they want to do is they want to modernize the definition of who a cap exempt employer is. So as we know, nonprofits and governmental research organizations are cap exempt. I think they want to further expand that definition to include more employers or to clarify this further. So let's wait and see what they do on that. Also, provisions to ensure that there's a bona fide job offer for specialty occupation position. So as of now, because of this IT serve versus Cessna and because for other various reasons, USCIS has not really been enforcing their speculative job requirement. So generally, if in order to file a H1, you have to show that you have a bona fide job offer for the person that you're filing for. And while that is still a requirement, they don't seem to be enforcing it as much as they used to before. So we're seeing H-1Bs being approved even for consulting companies, even when they don't submit a POW or a MSA, we are still seeing approvals. So they're trying to codify this requirement, and they're saying that if this regulation is passed, then they will ask for, and they will be allowed to ask for contracts, work orders, purchase orders, to show that the job offer is not speculative. So it goes back to square one, where they used to ask for it, now they're going to start asking for it again. So those are some of the updates that we have with reference to the H-1B. I wanted to also give some updates on with reference to the family-based, the availability of visa numbers, etc. There has been a publication, Visa Bulletin, as you know, is published every month, and the Visa Bulletin has come out for January. So I wanted to give you an update on the Visa Bulletin for January, because there has been quite a lot of change or forward movement for some of the employment-based categories for India. So I thought that's an important change to let you know. As you all know, in order to file a green card, your visa number should be available, and the availability of the visa number is published by the Department of State in their Visa Bulletin online every month. So usually the Visa Bulletin for the previous month is published in the is published in the present month. So for example, for January Visa Bulletin, we have already received that Visa Bulletin in December. So they usually do it before December 15th. Before the 15th of the previous month, they give you the Visa Bulletin for the next month. So in the once you get the Visa Bulletin, there are two tables: dates for filing table and final action date table. So every month, USCIS will let us know which table to use. If you're using the dates for filing table, be aware that you will not actually get a green card based on that table if you're filing, but you will be allowed to file a 485 and get all the benefits of the 485. If you're filing based on the final action date table, then you will immediately be eligible to get a green card as long as your dates don't retrogress while your petition is still pending. Because as we know, the 485 does take time to process. It takes about a year. So the biggest change that we've seen in the visa bulletin for January is the rapid progression or surge forward of EB1 category. So the EB1 priority date, excuse me, for India has moved ahead to September 1, 2021. This is a huge jump, a jump of 3 years and 8 months. So there are a lot of you out there who will now qualify to file an EB1. Please go ahead and do so in January itself before your visa number again retrogresses, because we don't know what will happen in February. So if anybody out there who has a visa number of September 1, 2021 or earlier, you should go ahead, in EB1, you should go ahead and file your 485 immediately. For China, the dates have also advanced to July 2022. And for other countries, it remains current, which was the case in the previous bulletin also. Now, that is for EB1. Now for EB2, let's see what's happening for EB2.
Yeah.
For EB2, the cutoff date for India moves up by 2 months. That is, it's moved up to March 2022. March 2012. From January, it's moved to March 2012. A slight movement. Some movement is better than nothing. So 2 months movement. For China, it's moved to June 2020. And for rest of the world, it's moved by about 3 months. So that's also, quite a good movement. For EB3 category, India has advanced by 1 month. So it was May 2012 earlier, now it's June 2012. China has moved to September 2020, and EB3 dates for all other countries has moved up to August 2022. That's a movement of 8 months, which is not bad. Also for EB4 category, all the countries have moved up by about 4 months, so that's not bad. EB4 is for religious workers. And for EB5, which is the investor visa, any of you out there who are interested in getting a green card faster should apply for an investor visa. That's EB5. For EB5 category under India's unreserved, that is immigrant visa numbers not set aside for rural high unemployment infrastructure projects. There's a separate cap for them, but for the general cap, it's moved ahead to December 2020. So that is a really good forward movement for EB5 India as well. China as well has moved ahead, and worldwide is current. Now, for dates for filing chart, as I said, there are 2 different charts, right? For dates for filing chart, India has, for EB1 again, has moved up significantly by 1 year and 6 months. It's moved to January 2021. It was in 2020 earlier. Again, for those of you who have these priority dates, please don't miss this opportunity to file your 485. China also, there's a forward movement of 5 months, and worldwide there is no forward movement at all for EB1. It's still, it remains current, so there's nothing for it to move forward. For EB2, there is no change for dates for filing, unfortunately. And for EB3 as well, there is no change for dates for filing. So as we see, the change is mostly in EB1 category for final action dates, EB2 final action dates, EB3 final action dates, marginal movement, and for dates for filing, EB1, India has changed quite a lot, but the EB2, EB3, there's no change at all. Now going to the family-based categories, because we shouldn't forget family. There is a forward movement for Indian nationals for F2A by 8 months, which is a significant forward movement in final action dates. F2A is permanent resident spouse category. Excuse me. So if you're married to a permanent resident, please look at your priority dates because they have moved. But otherwise, for dates for filing table, family-based case also have dates for filing table. That hasn't moved at all. So there's really no movement at all in that regard. So now that we have talked about visa bulletin, it's also important to see what's happening with the green card numbers this year, what happened last year, so just a short summary on that. And this is also an update because, there was a recent FAQ posted by USCIS on the numbers that are available this year and numbers that were available last year. As you all know, we're in 2024 right now because the fiscal year 2024 started in October. So as of 2023, there were employment-based numbers. There were 197,000 employment-based numbers, out of which India gets 7% of it. In addition to that, there were 10,000 numbers set apart for EB5. And USCIS is saying that they have used up all the numbers. Now, compared to that, to this year, there are less numbers available. It is now only 161,000 numbers are available. The reason why there's a discrepancy between last year and this year is there are less numbers that are rolling over from the unused family-sponsored visas. Last year, there were more numbers that rolled down from the family-based category. This year, there are less numbers, 30,000 less. So we only have 161,000. There's still some numbers that have rolled down, but it's getting less and less. If you see in the previous years, it's been 200 and something thousand during COVID, especially when the consulates were closed and the consulates were not using any of the visa numbers, and only the people who were in the US were using the numbers. Many more numbers were available, especially for Indian nationals. So as of this year, as I said, only 161,000 are there available. And of course, you have the 10,874 set aside for the EB5 category. That's the investor visa category. So we have, less number. Therefore, it means that there is likely to be more retrogression, and it takes longer to get the green card, unfortunately. Just quickly, I know we have only 1 minute left, but as a result of this whole visa crisis, a new bill has been introduced recently, as recent as December 1st, HR 6542, where they intend to amend the Immigration and Nationality Act to eliminate the per country national numerical limitation on employment-based cases. So if there are no numbers at all cap, then everybody will be able to file. For family-based cases, they want to increase the numbers. For employment-based, they want to remove the cap completely. And so far, it's been bill has been introduced in the House. It has to be passed by the House, passed by the Senate, go to the President, and then it becomes law. So it's a long way off, and many bills have been introduced in the past, and nothing has happened. So let's hope this bill has better luck. I'm done,
Yes.
Shivani. Thank you.
Yes. Thank you so much, Ms. Reddy, for tuning in. It was lovely having you on our show. Thank you again for the viewers for tuning in. You're watching Sakshi TV with me, Shivani Raj.